You may continue. Perhaps I will supplement. The legal advisor very kindly read the recommendation of the FATF. We just copy and paste the wording. As the legal advisor said, we are not free to choose words because other countries refer to the same wordings as well. Legal advisor, perhaps I will supplement. Well, that is whether to copy and paste the wording of the FATF recommendation. In Singapore, the rules that applies to lawyers also uses the terms prepares for or carries out. In the UK, the subsidiary legislation passed this year used participation, so it's their own interpretation. That is money laundering, law, and in Section 11, it applies to lawyers. It doesn't use the term prepares for or carries out. It uses participates in, and then it says.
個 transaction 咁即係協助規劃或者執行一個交易啦。Acting for or on behalf of a client a transaction 咁其實後邊。
It seems that the latter part carries a wider meaning, otherwise acting for. However, for the English subsidiary legislation, they are subject to evaluation next year. We don't know whether they will be passed. They will pass. Perhaps to be on the safe side, we should copy and paste the wording of the FATF. I don't think it helps. Well, it doesn't really matter. Let's move on. Page 6 is the same. Please, hold on. 5A, bracket 4, that is in relation to real estate agents. I have some questions. Well, it also uses carries out or prepares or the word involved in copies from FATF. And in the UK, they say carries out estate agency work, and it says including transaction of properties outside the UK. And in the Hong Kong Cap 511 Estate Agents Ordinance, it says is an interest of landed property, including those in or outside Hong Kong. So I would like to ask, in relation to this provision, does it apply to transactions of properties outside Hong Kong? Well, the spirit of this provision is for CDD. The location of the property is not affected to be taken into account. Mr. To. Well, we're on page 6, bracket 4, real estate. It doesn't specify where. That means it's presumably Hong Kong. The scope of application is limited to 4. That's my understanding. Buying, selling, or selling of real estate. Well, if it doesn't specify, that means it refers to those in Hong Kong, not outside Hong Kong. It says here that when a real estate agent engage in certain conducts when they're involved in transaction concerning buying or selling of a real estate. So it's the business that is the main point, not the location of the real estate. So it includes in and outside Hong Kong. Well, it includes the business conducted within Hong Kong. What about the location of the of the matter under the transaction? Well, I think the spirit is to find out who the client is. When a client commissions you to entrusts you to do certain things, you have the duty to record the particulars of the client. And as to what the client is interested in, as in types of business, is outside the scope. Well, it says as defined by Section 2(1). You mean the definition of estate agent or buying and selling of real estate? You say as defined by. But what about before that? We'll provide the definition of estate agent. It doesn't cover all estate agents. Of course, it follows the current estate agents ordinance. That is, those that are governed by this ordinance. So, Section 2(1) of Estate Agents Ordinance usually it refers to the interpretation. So, is the definition of estate agent or the definition? Well, my understanding is the clients, because it's defined in Section 2(1). Cap 511 applies the concept of land and property. Here it says real estate. It doesn't specifically define that it includes land outside Hong Kong. I think that for general way of interpretation, when it's not specified that it's outside Hong Kong, then it means it applies to within Hong Kong. I think Mr. To is of the view that since it's not defined to include land outside Hong Kong, so when a transaction is conducted in Hong Kong, you have to conduct CDD when it's transaction of land within Hong Kong, not outside Hong Kong, because it's not included in the definition. Under Cap 511, the definition of land may not be relevant because in this provision, the concept to apply is real estate, not land. I wonder if the administration agrees. But you copy and paste that from the convention. What follows after as defined? So what estate agents, buying and selling, or the definition of a client? Or all three? As the legal advisor said, well, as defined by the ordinance refers to client. So I want to ask the legal advisor, is it clear enough? Do we have to specify client as defined? Or it follows right after client, so it surely refers to client. Yeah, that is the same for Chinese and English as well. Because there are no, well, these other concepts are not included in Cap 511. So the administration is satisfied that the way it is worded as copied from the convention does not include properties outside Hong Kong, or you think that it includes properties outside Hong Kong. Well, we are objective oriented because we are preparing for the peer review. So we want to get prepared to meet the standard. As the legal advisor said that in the UK they choose to use their own interpretation, but they have not passed the evaluation yet. And there has been examples that when some jurisdictions use their own interpretation, they did not pass the evaluation. The estate agent authority is preparing the guidelines. I think the most appropriate way is for the authority to formulate guidelines. I don't accept this answer. Well, I don't mind if you copy the convention. But what about the substance of the ordinance. It seems that by the way it's worded, it refers to real estate in Hong Kong only. Is that your understanding? The legal advisor raises one point. The estate agent ordinance currently does not govern land transactions outside Hong Kong. So it's mainly about transactions in Hong Kong or within Hong Kong. Mr. Low, is that what you mean? No. In Cap 511, when land is defined, it says this definition applies also to properties outside Hong Kong. However, it may not apply to this bill because this adopts the concept of real estate, which is not defined in Cap 511. So you're talking about, you may talk about two different meanings. Mr. To said you copies the word real estate. What is your policy objective? Real estate, does it include real estate outside Hong Kong? Our intent is to ensure that CDDs are done, and they are clients of estate agents, and the service is provided in Hong Kong. The location of the property is not of any material. The estate agent, when they take clients to inspect a flat, there will be agreement of inspection, and there may be recommendations of overseas properties. The estate agent will record basic information of the client, and that suffices. I don't think you can evade the question. Should this be passed? And the word real estate is written here. And if in the end, the definition of real estate refers only to those in Hong Kong, and the regulator will take legal advice, and for some reason they promulgate a guideline, perhaps after listening to you, says that it regulates real estate outside Hong Kong as well, then it may be ultra virus. Someone may take out a judicial review against you. Do you understand? If your policy objective is to include real estate outside Hong Kong, then you have to define it. Because real estate outside Hong Kong is not defined in the estate agent's ordinance. Do you need to give it another thought? Do you understand me? In relation to this point, perhaps we will clarify Mr. To's point and reply to you in written form. Let's continue then. Next is page 7. Page 7 is a section 7 and clause 8. It says that the regulatory body may, in relation to Schedule 2 about requirements of record keeping and CDD, promulgate guidelines. This is only an empowering provision. Page 8 is bracket 5, capital A. Currently, there is already a practice direction for lawyers, and if they choose to promulgate another set of guidelines, then they may do so. And if they want to refer to the current code of practice, they may do so as well. We are still talking to the Law Society about the wording of this provision, so there is a chance that it may be amended. Mr. Low? The administration just said that they may amend 5A. I noticed that in the Chinese version, it's mentioned in a correspondence. Let's refer to page 7. There are two terms, 指引, 導引. guidelines and guidance respectively. The guideline refers to the document and direction means the content. However, in 5.8b it says provides guidance. However, in Chinese the term is the same. Perhaps you need to change the second one to 导人, which is guidance.
Now we are going to amend section 7, 5A in one go. And we'll consider your suggestion. Chairman, sorry, perhaps I'm a bit slow. 5A, why does it only apply to the law society? What about the accountants? Other professional bodies? Why don't you have it? For other professional bodies, they will be captured by section 7, meaning that all regulatory bodies will be empowered, and they include the law society, and the estate agency authority, etc. All of the regulatory bodies can provide guidelines for their professionals, and this is already enabled under section 7. For subsection 5A, this is upon the request of the law society, because they have a practice direction P for their profession, and because of the practice direction P, they would like the administration to acknowledge the practice direction P in particular in 5A. For other guidelines, we do not specify in another provision. But even for the Hong Kong ICPA, they have a set of guidelines. The Law Society has another set of guidelines. I want to know whether there is any difference, technically speaking. Let's say if I don't have 5A, and let's say if we are to amend the guidelines, and then the guidelines will be promulgated, it will be followed by the members. But why all of a sudden we need 5A? Well, we respect the views of the Law Society. Mr. To, in previous meetings, this issue was also raised. The Law Society already has a set of practice directions P. We should respect that, and we've considered the views of the Law Society and the honourable member, and that is why we have this design. But it doesn't do, because you have another paper suggesting that there are 7 points that do not tally. Well, the Law Society can continue to provide guidelines according to Section 7.1 or this specific provision 5A, which specifies that a reference should be made to that practice direction. That is even more confusing, because we're supposed to follow one set of guidelines. If you have 2 sets of guidelines, it will be chaotic. That means even with just one word being different in one of the sets, then it will be chaotic. Well, we're not really concerned about this. Well, the administration hasn't come up with another set of guidelines, right? They respect the Law Society's guidelines. But Section 7, subsection 1 and Section 5A, if you're saying that there are no 2 sets, why don't we just follow one set? But I understand that there is no contradiction here. No, Chairman. Well, in fact, 5A enhances 7. No, but 5A only applies to the Law Society, because 7 already captures all regulatory bodies. No, 7 suggests that each regulatory body should publish guidelines for their own profession. So 5A is specific to the practice direction. No, but 5A, it says that respect should be given to the practice direction issued by the regulatory body. I understand that there is no contradiction here. Don't you remember, Chairman, I told you a number of times, even the administration admits that there are 7 points that don't tally. Now, for Section 7 and 5A, they're reflecting what is actually happening now. Now, the Law Society has the practice direction, and I understand from communicating with the Law Society that they don't plan to draw up another set of guidelines. They're going to use the practice direction. As for the Hong Kong ICPA or the Estate Agency Authority, they will draw up a new set of guidelines in accordance with Schedule 2 and Section 7.1. That is why we have this provision, because we respect the Law Society. But like Chairman said, there is no contradiction at all. Now, what happens if, let's say, the Law Society has a set of guidelines, right? We saw that. And then there are 7 inconsistent points, and they've changed that. And what should they follow? Should they follow 5A or 7.1? Now, when they revise the content of the guidelines, then 5A applies. That is, guidance should be provided in the practice direction. My understanding is that they do not intend to publish a new set of guidelines. So for 7.5A, it applies to the Law Society, and then it will revise the existing practice direction as the new set of guidelines. All right, understood. Page 9. Definition of terms in relation to the regulatory body which will be empowered to draw up guidelines. Page 10. Section 9 of the bill. In fact, Section 9 to Section 13, well, all the way, the company registrar will be empowered to exercise its power to implement the licensing regime for a financial institution or TCSP, and then the relevant personnel will be empowered to enter. I'm sorry, I was asking about page 9. She skipped it. Please allow me some time to flip over the pages. AML-CTF requirement. I don't understand this. Why is it subsection A and then subsection B? And then to a legal professional. Why specifically? It is applied only to a legal professional or what? Perhaps I can invite our legal professional to answer the question.
First, the definition refers to Section 5A, uses the term AML-CTF requirement. Section 5A applies only to legal professionals, the practice directions of the legal professional. That is why it only refers to a legal professional only.
Chairman, but it also contains accountant 5AC.
The term AML-CTF requirement is used only in Section 5A.
I'm sorry, the exact application of this is section? Oh, it is section 7.
This is Section 7, sir, not Section 5A.
Yeah, but why especially this requirement applies to legal profession? Is that additional?
It is.
That means the accounting professional need not comply with the Schedule 2, Part 2, 3, 4?
It's defined in Section 5A for everybody, but for Section 5 in Section 7, it's used only in relation to legal professionals. It's used only in Section 5A.
Okay.
And the other one in Section 5, there's a separate 5A. There's a separate definition for that applies to all the professionals.
No, but you look at subsection 7. It seems that this is only a connecting provision. It does not have a substance in this subsection 7.
Okay, wait for a minute. 盧生有些
Mr. Low would like to say something. Thank you, Chairman. Mr. To, perhaps you could read this. Page 9, subsection 7. It provides definitions for subsection 7. For AML-CTF requirement, it only appears in 5A. All right. So that's 5A-B2. So it's specifically in relation to 5A-B2, the AML-CTF requirement. That is why it only applies to a legal professional. But that is my question. Why do we have anything that specifically applies to a legal professional but not an accountant? Right. It refers to the 5A about the new provision. Let's continue. Page 10. Page 10 amends Section 9 of the Ordinance. The company registry personnel can enter the business premises of a financial institution or a TCSP licensee for inspection. No problem. Let's continue. Page 11. Sorry, Chairman. TCSP. What is it? It's trust or company service provider. Now we're going to provide a definition in Schedule 1. So who is in charge of the entry and inspection? Company registry? Yes. Yes, it's provided here. So the company registry is not confined to, the licensing division. You can have a whole team of personnel from, say, the Hong Kong MA, etc., for investigation. I think there is an enabling provision for the purpose of investigation. That's correct, Chairman. What's the purpose of the inspection? Excuse me. Let's say if you want to enter the premises, what is the purpose? Well, in the future, a TCSP will need to apply for a license with the company registry. Failing to obtain a license will constitute certain criminal offenses under this ordinance. And to implement the licensing regime, the company registrar will need to ascertain certain requirements by way of regular inspection. And this is actually a provision which we drew reference from a licensee of the FI. Well, but this is not about inspecting for the purpose of licensing. We're talking about licensees only. Well, it's not like unlicensed guest houses. You check guest houses to see if they have licenses. Well, we have the professional body's own regulations to check their compliance on CCD, whereas here the company registrar can ascertain compliance. Let's say if the personnel enters the business premises, if the licensee hasn't conducted any customer due diligence, then the personnel may need to check the relevant record-keeping requirements by entering the business premises as the last resort. Is this the last resort? Have you asked for, well, is it the case that you ask for documents to be provided in vain? I don't know whether the company registry has the practice of inspecting business premises. Mr. Low has something to tell you. I think this provision relates to inspecting TCSP licensees as for unlicensed premises. In 53 ZF, in a subsequent section, the authority will need to apply for a warrant from a magistrate in order to have entry. and that is about unlicensed operation. And if there is an investigation for this purpose, a magistrate's warrant will be required. My understanding is that this provision relates to customer due diligence checked inspection for TCSP licensee. Right, but on what basis? Is it that they refuse to provide documentation? Thank you for the question. Depending on the circumstances, if there is a suspicion, we will write to them to ask for more information, and if no information is furnished, we can invoke this provision to conduct an on-site inspection. When we enforce this provision, we'll also set up an on-site inspection team so as to check the licensee on whether the licensee has complied with the customer due diligence and record-keeping requirements. At present, we do have an inspection team which visits the offices of business premises to see if they comply with the company's ordinance. For example, if they have the sign of the company put up, if they have the register of members of the company and board of directors of the company. Do you have any code for enforcing this piece of legislation? For banks, I understand that inspections can be carried out anytime, but I don't think that it will actually be done. Only under extreme circumstances will the authority visit a bank. But here it says that at any reasonable time, so it means at any time. I'm concerned about how the power is exercised. Because after all, when you visit the business premises of a licensee, I want to make sure that it will be done in a reasonable manner because it's something major. For other authorities such as the Hong Kong MA or the Insurance Authority, if they are to enter the business premises, I want to know whether the same legal requirements apply. They're the same because for Section 9, at present, for financial institution, the authority can also exercise its power to conduct inspections. I think that Mr. To is right. I don't think the company registry would for no reason visit the business premises. It will only be done on a need basis. For example, as explained by the Registrar of Companies, perhaps there has been correspondence requesting for information to be provided, and after repeated requests, the company has not provided sufficient information, or that the information hasn't been updated. Under such circumstances, the registrar might need to visit the business premises to see if to check the compliance and the record-keeping requirements. And the company registry at the moment also conducts regular inspections on the compliance of the law. Because of the vast number of companies in Hong Kong, it is quite impossible for the registrar to visit each and every company. So it will be done only on the basis of suspicion, on a need basis, or on complaint. And this applies to the service provider. That is of monetary service provider. Under Part 5, the C&E department has a licensing regime. All right, you don't need to explain that. I know that. I am only concerned about this. Is it that if a lawyer is engaged in the trust business, no license is required because there is an exemption? What if we have a law firm with part of its resources set aside for trust business, and then another company is set up, and not the law firm itself, then the license will be required. But at the same time, the company might be situated in the premises of the law firm. I'm concerned about the LPP, the legal privilege client privilege. So if you can enter the business premises anytime, it means you can even enter the law firms anytime. I think you should take note of that. Section 81 is on LPP, safeguards. I know that's in theory the case, but when you enter the business premises, there may not be a clear division of the premises. I mean, once you enter the business premises, you may have access to everything.
Mr. Low, do you have anything to add? Thank you. Thank you very much for Mr. To's question. As the legal advisor said, this provision is covered by LPP, and when we carry out enforcement, we would look at the constraints imposed by LPP. If we are to make site inspections, we would generally issue a letter first to inform the licensee when we will come and the relevant arrangements required. We would also tell them what kind of information we are looking for. As for this ordinance, the scope of inspection is only on customer due diligence and record keeping requirements, so the scope is rather limited. In our letter, we would specify what information we would inspect so that the information would be prepared ahead of time. As our legal advisor said, Cap 81 encompasses legal professional privilege. So if an inspection is to be made, the scope of evidence collection is very narrow. As Mr. To said, even if there are different information within the company's registrar can only inspect specific information. It is not as simple as that. And in A it says entering the business premises, and B, inspect and make copies, etc. What is meant by any record or document relating to the business carried on or any transaction carried out by? Let's say we have a limited company and there is a licensee. So when you inspect the company, which part belongs to the trust and which part to the law firm? Mr. To, this is the same for other ordinances. For example, for some criminal ordinances, law firms would not be money changers. Law firms are protected by the legal professional privilege ordinance. I'm just reminding them. You talk about money changers, that's irrelevant because a law firm would not engage in money changing or money exchange activities. If the relevant ordinance is unclear, we can make amendments. If you feel that the protection is not enough, you can make amendments. I'm just asking about the enforcement. You are just reminding the administration. So have you heard him? Yes. Chairman, so why can't I do that? Chairman, I've always been very clear, but the administration refused to give a direct answer. They were talking about money changes. That's why I said law firms would not be money changers. So please don't mention money changers anymore. Page 11. The powers in relation to regular inspections. And after financial institutes, we would insert institution or the TCSP licensee, and page 12 it's the same. Nothing on page 13, page 14. On TCSPs and their premises, we stipulate what kind of premises there are, and page 15 would amend section 10 of the ordinance. I'd like to ask about page 14, brackets 1. Why? Well, I'm referring to I. After I, we have Roman numerals 1, 2, and 3. Why is there such a need to insert these parts? Are these included for FIs as well? I know that you might not want to hear the words money changes, but there are requirements on specific premises. In other words, the services can only be conducted in specific authorized premises, but for the companies, there are no such requirements, and these businesses are unique in nature, so specific premise requirements are not needed. And as I said, there would be inspections made, so we are providing definitions on what premises are allowed. I do not quite understand. For premises, this an office can be a premises, and a place for meeting the client might also be a premises. So you can just follow the dictionary meaning. So is there anything beyond the dictionary meaning, Mr. To? Money changers must be operated in specific premises for the legal profession. No, I'm referring to TCSPs. Apart from trust companies, do you realize that trusts or company services can be provided elsewhere? If I want to purchase a property, the agent can come to my home. Is that possible? I don't quite understand. Perhaps you just let them answer this question. Can you allow her to answer? Because what you said might not be what they have in mind. Well, I'm just exchanging my views with you. They still have to provide an answer. Why don't you ask them? If an agent visits your home, would your home be inspected? Well, that's what you said. So please explain the subparagraphs 1, 2, 3 for TCSPs. If they have an office in Central or Causeway Bay, a lot of operations can be carried out in computers, so that would be their office. So why is there a need for the other provisions? Under paragraph I, it applies to section 9 on the powers of entering a premises, as Mr. To said. Subparagraphs 1, 2, 3 further clarify the dictionary meanings. The scope of the power is more clearly defined so that members of the public and licensees can understand what constitute business premises. Like what Mr. To said, we are just trying to further clarify the dictionary meanings. And under Section 9, for banks and other institutions, everything is laid out clearly. So for the sake of integrity, for TCSP premises, we are inserting paragraph I. So that is a problem. For subparagraph 3, to extend the example given by the government, by the chairman, computers would store data and records. So you just want to identify that computer because their office might be, or their operation might be paperless. So if the computer is stored at home, can you inspect the home without a warrant? When a company is set up, they have to inform the registrar of their office address, and the company's registry would inspect the premises based on the address registered. So why is there a need for paragraph I? Mr. Oden Chow. Thank you. I've been following this issue carefully, and on page 13, under business premises, under paragraph A, well, in relation to an authorized institution and so on and so forth, and including 1, the institution's principal place of business in Hong Kong, 2, a local branch or local office established or maintained by the institution, 3, a place of business of the institution used solely for the purposes of, and there's a further ABC. A, the administration of the affairs or business of the institution. B, the processing of transactions. Or C, the storage of documents, data or records. So for the new provision inserted in page 14, for under subparagraph 1, the administration of the affairs or business of the TCSP licensee to the processing of transactions and so on, they are similar to the wording used on page 13. Sometimes the professions have to observe consistency, but when we look at the definition of business premises, and they refer to the principal place of office, local branch or local office, and place of business for the purposes of the administration of the affairs or business of the institution, the processing of transactions, and so on. So for the layman, they might think that the paragraph I would refer to other places. So people might have the impression that the principal place of business refers to something else, and the place of business for the administration of the affairs or business of the TCSP licensee and so on refer to something else. So can the government clarify this? Mr. Low. Thank you. On page 13, section 15A, 1, 2, 3, they apply to authorized institutions like banks. The wording is a bit different, and subparagraph 3, it says a place of office used solely. But on page 14, there is no such word or words. Mr. To asked whether inspections can be carried out on your home, I think it must be a place of business, according to page 13. Any premises in which the TSCP licensee carries on business, including a place of business used for the purpose of 1, 2, and 3. And we have been rather consistent in the past for inspections of residential properties. A warrant is needed if you are to inspect the licensee, whether for parlors, restaurants, and etc. The authority can make inspections without having to involve the courts or judges. So for residential property, you have to apply to the courts. So that is how we draw the line. Things might have changed, and in the past, a place of business might be needed to meet clients, and nowadays, people might rely solely on the computer, and there are a lot of one-man teams. So everything is on the computer, and there won't be separate files. So let's say if there's a 200 feet office and you can search that office. So if you say that TCSP's warrants special treatment, you might consider homes as a place of business, and you can enter a home. I think. Well, I think the key is how you define the place of business. If I bring a computer home, is my home considered a place of business? Thank you. I think in actual operation, the question is easily solved. We would request the licensee to tell us their place of business. We have a register containing the names and addresses of the businesses for public inspection, and this enhances transparency. Registrar, as Mr. Toh said, if I conduct my business solely with my computer, I still have to be licensed, and I must provide an address, and I have to give you the information. So I have to give an address. So I must have a premises. Even if you bring your computer around, you still need a place. It depends on the address registered as place of business. So that's problem solved. So you can just remove paragraph I. You can search the address provided. So can we delete I? Or you can just say that I refers to the place of business. Is it possible to remove I? If that is indeed their thinking. I asked the administration about another aspect. For mortuary services, there must be a fixed place of business. And even though you have to inform the company's registry about your place of business, but you can still conduct your business everywhere. So you said you will first make a request before conducting a search, and you might be ignored, and then you might decide to do a search. Of course, you would visit the place of business registered, right? Is that what you mean? Thank you very much. As the registrar said, when we drafted paragraph I, we made reference to existing provisions on authorized institutions, etc., and we have defined business premises. That way, members of the public and companies can follow the same standard definitions, and it makes it easier for law enforcement officers to deal with disputes. So I refers to place of business, and we would refer to the information registered by a company. We do not intend to visit people's homes or other places in search of the information.
睇你寫乜嘢啊嘛。
Well, it's useless for us to tell us what your intention is. It's what you have written here. If it is the premises reported, then there is. That's it. Or you can include Roman 1, 2, 3 under place of business reported. Instead of you saying that, well, let's go to that place and then we will decide whether we have the authority to search the place. So I think these are two different approaches. Let us give you a written reply. We will deal with it very carefully. There is flexibility. If we can only deal with the address reported, then our hands will be tied. Our starting point is to build in more flexibility. Given what members have said, we will go back to think about it and give you a written reply. If one can only conduct business at the premises reported, that means if you carry on your business anywhere other than that premises, then it is against the law. Well, that means it's providing false information. But by the looks of it, if you take away I, it will give rise to other problems. Let me give you some supplementary information. Mr. To is 100% correct. However, if we remove I, then it will create operational difficulties. Of course, they will have to report the place of business to us. If they change the place of business, they have to notify us. If a licensee changes its place of business but have failed to notify us, deliberately or not, then it's a breach of the licensing condition. And under this circumstance, I will kick in, because the premises where business is carried on is not the place reported. Then we will be able to go to the other place where business is actually conducted to do our search. What's so special about I? I is there for the sake of completeness by covering TCSPs. We have not added anything. We only clarify the dictionary meaning. Mr. Low, this is only a suggestion for your consideration. If your concern is that searches will be conducted at your home, then it says here that a place of business used for the purpose of 1, 2, 3. Perhaps you can say it includes a place of non-domestic purpose. If it's written like this, it can be anywhere. Say, I meet a client at Starbucks. Then you will search Starbucks. If my client goes to the chairman's home, then you will search the chairman's home. That's what is meant by I. Because my computer is where documents are stored. So wherever my computer is, you can search the premises. Say, well, Mr. Wong has 8 computers, and mine is there as well, and you don't know which is which, so you have to search all 9 computers. So it can be anywhere in Hong Kong. Whether it is non-domestic is one thing. If I go to a company and regulators want to check the licensee, then they will have to search all 100 computers there. And you will have to seize all documents to check them all. I think you need to think about this again. Well, I'll use the example of money changers. Say it's a designated place, say it's A. Like you say, they go to B to open an office without reporting, then you will charge them with conducting an illegal business. And then now they say B is reported, and then they go to B. Then you already have a provision on which you enforce the law. If it's anywhere, and if the computer goes to the CE's office, then you will go to the CE's office to look at all computers. I think that is too scary. We will go back to think about it. Mr. Holden Chow. Riding on what Mr. To said, I only have one thing to say. The way it's written, it looks like that you have not taken into account the modus operandi of the new generation, where mobility is king. Say, if I want to make use of the loophole, I give you an address, say ABC Industrial Building. That's my place of business. But it's only a front. All storage is on my laptop. And my laptop will not be placed at that premises. If you want to inspect it, you will go to the industrial building only to find that it's empty. You still use the concept of premises. But in this day and age, premises is meaningless. The premises may be empty. All the documents will be stored in a device. And there are many ways for me to evade your inspection. At the outset, I said that you want to mirror the way it's worded on page 13. I understand. But now, I realize that the way it's written fails to take into account the mobility of doing business nowadays. Times have changed. Please pay attention to this, because there are secretariat companies, the tools used by the business operator may not be placed at the reported premises. You need to strike a balance as to how you deal with it. Any other questions? If not, let's continue. We now move on to page 15. This is about offences for non-compliance with requirements imposed under Section 9. And it may be a fine or imprisonment. These are the amendments. On page 16, now page 17 is about appointment of investigators. The registrar for companies may appoint a public officer of the company registry to carry out duties. Okay, no questions. Continue. Page 19 is section 12. Investigators appointed by the company registry may go to the premises to ask for documents and records. It's just that they will not break in to gain entry. I want to ask, C, why do you want to add bracket C? So, page 17, bracket 1. After lowercase b, you add C. It seems that the way it's written is different from other provisions in financial institutions. 53 and the 53Z and ZD will appear later. It refers to actions taken by the registrar. Say, for example, the licensee has contravened the requirements under Schedule 2 or licensing conditions. The registrar may take disciplinary actions. So 53Z and 53ZD relates to the exercise of power by the registrar. And that refers to investigations made. Well, then we will have to refer to 53Z and ZD. That is in relation to disciplinary sanctions. You will find them later. So, well, what would constitute an offense? What would constitute a disciplinary action? Can you give me some examples? I just want to know, just one example maybe. Do we need to go to 53 then? No, just give me an example. Because there are some that would end in criminal penalty. What are the more minor offenses? Well, they are written in section 53Z and 53Z. It says that, say for example, contravention of CDD requirements, record-keeping requirements. In relation to TCSPs, that it carries no criminal penalty, but just disciplinary action. It's page 52. So for TCSPs, they are different from lawyers, accounting. They are similar to lawyers and accountants, but not when compared to banks. That's right. I see that for some offense sections you have added licensees, or have you not? Is there one that refers to the criminal offense committed by TCSPs? Well, the newly added provision is to carry on these businesses without a license. That will be the only newly added criminal liability. So what defines the carrying on of a business? Say, for example, someone providing a service, a one-off service in relation to a will, and the lump sum is paid. That has already been answered. When? At the outset of this meeting. It's 37517 to 18 bracket 05 paragraph 5. It's paper bracket 02, paragraph 5. Can you find the document? Yes, but it's rather short. It says 331. Did you say 331? No, well, I will wait. Sorry, I don't know that it's there. I thought there would be more papers. Or perhaps you haven't read them all. Let's continue. Now we're on page 19. This is section 12. It's about investigators requiring the parties to produce records or documents. Next is page 21, referring to section 13. That is offenses of non-compliance with requirements imposed under section 12. That is production of documents or records. Any questions? If not, let's continue. 22, 23, and then 24. 24 is part 5. Sorry, I have some questions. Is page 20. Yes. Bracket 7. Disclose any information. You've added something. Or produce any records or documents related to the customer. It's rather wide. It's already there. Well, let's not talk about what's originally there. Let's hear from the administration. Say if I provide trust services to Li Ka-shing, that means I can ask for any information from Li Ka-shing? Let's hear from Mr. Low. Well, it's the negative. It said it won't. So what are to be provided? So what is the scope? How narrow is it? It relates to information obtained during a routine inspection. The registrar shall not provide such information to other organizations. This is a limitation of the power of the registrar, save and except that the disclosure is based on a certain need, say for example, a judicial proceedings. Save and except that the registrar shall not provide the information to other organizations. So what could the registrar obtain originally? Say for example, the licensee. Well, let me put it this way. You now ask them to do CDD. I have obtained 8 sets of documents. Now the registrar comes to me and I will give the registrar 8 sets of documents. Do I have the duty to find more documents related to the client to provide to the registrar? Let's hear from Mr. Low. I think, well, let's go to page 19. 12 to 8, Roman 2. So is whatever I have. I don't have to find additional information for you. Okay, let's continue. Now we're on page 24. Is part 5, regulation of operation of money service. Well, the licensing regime has been in place for several years, so we have introduced some technical amendments. First is the definition of the ultimate owner. Well, if there is an ultimate owner of the licensee, then we will see if that ultimate owner is a fit and proper person. And the definition of ultimate owner is it used to be not less than a 10% share. We will relax the requirement by amending it to more than a 25%. You will find this amendment on page 24. The second technical amendment appears on page 27. Sorry, please pause there. That is the result of consultation. It is rather arbitrary. I don't know how you draw the line. What's the difference between 10 and 25? The definition of ultimate owner, we have made reference to the company's ordinance. We refer to beneficial interest. Under that, the standard of 25% is used. So we think that for AML bill, we need to adopt 25% just for convenience. We have drawn reference from the practice of other jurisdictions as well as the requirement and definition of the FATF. This is to achieve consistency with the company's ordinance, because under the company's ordinance, then more than 25% is used. No, I think it's about an international requirement. So this is also in line with international requirement as well. Yes. Well, when it comes to keeping information of beneficial owner, 25% is used under the company's ordinance. So 25% is more than the international requirement?
Yes.
Well, Chairman, when we enacted legislation in relation to banks, right, but back then the FATF hadn't come up with the new standards. No, not true. When did you apply the 10%? Well, about the AML-CTF ordinance, it was drafted in 2012, and the FATF later revised its standards. And for this one, we have drawn reference to the latest standards and also the practices adopted by other jurisdictions. We find the 25% appropriate. I'm not talking about whether it's appropriate. I'm asking about their requirements. For FATF, the recommendation doesn't specify an absolute percentage. Rather, it refers to 25% or above as an example. So all other major jurisdictions adopt the threshold of 25% or above. But back then, why did you adopt such a threshold? 10% did you offer on your own? Let's take a look at the legislative process in 2012. We had a different team back then. We could check the Bills Committee's records. Well, Mr. James Toll was there. Right, I was there as well. But we don't have any recollection. But I think that the 25% or above is welcome. It's a relaxation. But was Mr. James Toll's question? I need to make it clear. There is no percentage defined by the international organization. The example is 25%, and then you think it would be all right to follow the example of 25%. And also you believe that relaxing the threshold from 10 to 25% will not face any objection, all right? Mr. Odin Chow. Sorry, Chairman. I don't want to go back to the page, but I'd like to leave it, put it on record, because on page 29 you were referring to the submission of document for investigation. Now I'm also reading the blue bill at the same time about the investigators or the method of investigation. A magistrate's warrant will not be required, right? And then I see 53 ZF in the blue bill. The magistrate can issue a warrant for entry into a premises if the magistrate is satisfied that there is a need to do so. And this is just a comment. Perhaps you have given it a thought already. After all, if the investigator can enter the business premises and require the submission of documents, and that the investigator doesn't need to go through the magistrate, and perhaps another member already made this point. Normally, in our judicial system, if we are to conduct any search of a premises, a magistrate's warrant will be required. Well, Mr. James Toll referred to the documents set out in the ordinance, but sometimes people might be concerned because for Section 13, it sets out a criminal offense for non-compliance with a requirement. This is quite a major power given to the authorized officer. I want to know whether you'd rather prefer a warrant be issued by magistrates first. Perhaps you've given it a thought. Thank you, Mr. Chow, for your comment. For 53ZF, why is it that a magistrate's warrant will be required before entering the business premises? Well, this is about unlicensed operation of money service. It's quite serious, and that is why before entering a premises, we require a warrant to be issued first. Whereas for the regular inspection in section 19, for the registrar of companies to visit the business premises to check whether records are kept, whether it is licensed, well, the offences involved are relatively minor, and that is why we're not asking for a magistrate's warrant. Well, usually when the company registry checks our documents, checks whether papers are properly filed, it's part of the routine inspection. Usually, a warrant is not necessary. And even if there is a request for information, the scope will be very narrow. Mr. James Toh, Chairman. I think Mr. Holden Chow is right. On second thought, we should ask for a warrant. Under normal circumstances, for unlicensed premises, you need a warrant. For licensed premises, however, you can do whatever you want. No, it's true. It's so written here. You have access to everything without a warrant. Let's say if you visit a disco parlor, and then you turn on all the lights and ask for ID cards and licenses, etc. Whereas for a trust company, this service provider may be helping out a wealthy family with a trust of several $10 million, and then you can invoke this provision, and the registrar of the company can then go through all the papers. I don't think it's reasonable. I think it's risky. I think at least you need to get a warrant from a magistrate. Because on the other hand, if you have reasonable ground to suspect that there is unlicensed operation in the business premises involving a major crime, say money laundering, then if you enlist the help of the police, if it involves a serious or organized crime, no warrant is necessary. So if you need a warrant for checking unlicensed premises, whereas for licensed premises you have access to all the records, I think it's unfair. I give you a chance. Go back and think how you can convince us. At least convince me. Perhaps Mr. Chow could be convinced quite easily, but not me. So I think that this is an even more serious issue than changing the record-keeping requirements from 6 to 5 years, because this is a rather serious matter. Right, your point is noted. Mr. Holden Chow has raised his hand. Please allow Mr. Chow to speak. Thank you, Chairman. Chairman, let me give you one example. Earlier, I took part in the scrutiny of the subsidiary legislation on selling liquor without a license, and it also touched upon an issue of gathering evidence. At the Bills Committee, the same issue arose because no warrant was required, and the issue was raised at the Bills Committee. If my memory serves me right, the administration told the Bills Committee that they would go back and consider the point and may move a committee stage amendment. Now, of course, this is for the administration to consider, but my suggestion is this. As a lawyer, when we raise a point of law, we consider how this is drafted. If no magistrate's warrant is necessary, we are not sure whether it will be contravening any human rights provisions. and then this bill will be flawed. Well, I welcome any views from the legal advisor, but perhaps the administration can think about it. Yes, the administration would go back and think about the comments made by Mr. James Ho and Mr. Holden Chow. Just a supplement, say for a license check, whether the license is put up inside the premises, whether the operation is sound in the premises. For that kind of inspection, it's something else. But now you're talking about an inspection that allows you to comb through everything, have access to every record. I think it's out of proportion. Especially if some conglomerates are involved, there might be politics involved. Guo Wen-gui recently made an accusation in relation to Hong Kong. Right, it also touched upon the entry and search aspect of our authority. Well, we don't know what that case of Mr. Kwok is about, so let's spare this example. Well, do you know anything about Mr. Guo Wen-gui's case? Are you familiar with the case? But he made an allegation. Do you think it's true? Well, does any allegation automatically becomes fact? Well, but this is not within the scope of the Bills Committee anyway. Let's move on. Thank you, Chairman. Page 27. About the second technical amendment on regulating the money service operators. Can we take a 10-minute break for our health's sake, Chairman? 5 minutes, not 10 minutes. All right? All right, 5-minute break then. I see that they would like to answer the nation's call as well on that side. On Mr. To's request, okay.